Well, a very good afternoon, everyone, and welcome to this second session for the In-House Community Congress Vietnam 2020. For those of you who don't know me, I'm Tim Gilkerson. I'm the founder of the In-House Community, and it's a great pleasure to have you all with us today. We're very pleased to have Tilleke Gibbins present on what are very hot topics right now: data and cybersecurity and online transactions in Vietnam. And for those of you who don't know Tilleke, I'm sure most of you do know Tilleke, but Tilleke Gibbins is a leading Southeast Asia full-service law firm, headquartered in Thailand, but with offices in Vietnam, Cambodia, Laos, Indonesia, and Myanmar. With more than 120 legal professionals across its Hanoi and Ho Chi Minh City offices, Tilleke is one of the largest international law firms in Vietnam and has been named Firm of the Year for Vietnam for 7 consecutive years by Managing Intellectual Property magazine. In addition, it's one of the only 2 firms in Vietnam ranked Tier 1 in TMT by both Chambers and the Legal 500. So they've got a great outfit. And speaking for the firm today, we have Giang Hong Chun, who is a consultant specializing in TMT law, who formerly worked with Vietnam's Ministry of Information and Communications. And joining her, we have Waewpen Piemwichai, who's a Thai qualified lawyer and registered foreign attorney in Vietnam, who leads the firm's day-to-day TMT practice. So thank you both for joining us today and presenting to us, and over to you.
Presentation. Thank you, Tim, very much for your introduction. And hello, everyone. We are very honored and very happy today to have a chance to present to you on data and cybersecurity and online transaction in Vietnam. I'm Giang, and my colleague is Waewpen. Today we will present on 5 topics. I will present from topic 1 to topic 3, and my colleague Waewpen, she will present on topic 4 and 5. So let's start. First is overview of data privacy law. So the privacy is a fundamental right, and it's recognized by Constitution of Vietnam. There is no uniform and comprehensive data privacy law in Vietnam. Instead, the regulations scatter throughout different regulations. For example, Constitution, Civil Code, law on network information security, cybersecurity law, IT law, law on Decree 52 on e-commerce, Decree 72 on Internet Consumer Protection Law, and also you can see anti-spam and other like penalty, like Decree 15 2020, which is just released and effective, and Decree 185. So there are quite a few regulations on data privacy. Today, I'm going very briefly on the main point of the data privacy law. So the term and principle usually used and regulated in the privacy law. So you can see that in Constitution and Civil Code, you can see the terminology like private life, personal secret, family secret, private communications. And generally, those information is information people want to keep secret and confidential. And disclose of this information without the information owner consent can cause a negative effect on them. So it is defined in Decree 185. And throughout the different pieces of legislation like the IT law, the Decree 72 on Internet, the cybersecurity law, or the law on network information security, you can see the terminology of personal data or personal information. Basically, personal information is information associated with identification of a specific person. And this, you can find the definition in Decree 52 or 72 or law on network information security. So what are the principles? The principle is that the rights to private life, personal secret, and family secret are protected, and safety of confidentiality, safety to confidentiality of private communication is secured, and those principles are clearly regulated in civil code and constitution. And also very important principle is consent principle for the data privacy law. So now I talk about more on consent principle. So what are consent principle? When I use the word processing, it will be very broad meaning. Processing including the collecting and editing, using, storing, providing to any third party, transferring, sharing, and publishing of information, personal information. So what is consent principle? Consent principle is that if you want to process the personal information of a particular person, so you have to have consent to that person, of that person, unless consent for such transaction is exempted by law. So consent be expressed or implied consent. So there is certain regulation which clearly regulate that consent must be expressed. For example, e-commerce rule, you can find in Decree 52. But for some other laws like consumer protection law or some other law, the form of consent is not so clearly regulated. But usually, out of prudence, we usually advise the company, the clients, that you should seek the express consent, the opt-in consent for better protection. So and also for the consent of the minor. So the civil code regulating that the people less than 15 years of age is not deemed to have a legal capacity to give consent. So for those people from less than 6 years old, then you have to get consent from their parents or their legal guardians. From 6 to 15 years old, their consent must be accompanied by their parents or the legal guardian consent. Only when they are from 15 years old and more, you can have their own consent. Consent principle also have exemption too, and you can find exemption in the IT law or Decree 52. So these are the 4 exemptions in the consent principle. For example, you don't need to ask for consent if the information already published on the website. You don't need to ask for consent if the information you collected and processed is for concluding the service purchase contract, etc. And I also talk briefly about the anti-spam. So there is an interesting thing that the Decree 91 2020 is just recently promulgated, and this one will go into effect on the 1st of October 2020 and replace the existing Decree 90. But here I list out the common rules in anti-spam. For example, the sender only send after obtaining recipient consent, and you have to set out the opt-out mechanism for the recipient to opt out if they do not want to receive any more messages or email. And they also set out, the decree also set out the quantity, the number of email or text message you can send per day, and the time you can send per day. Also, the new decree is very interesting that they set up a system for reporting spam. The new decree also regulates the cold spam or the cold advertising. The new decree also set up the list for not receiving advertising text messages or advertising call, and build an IP blacklist which spreads the spam email. So this is the new decree 91, which coming into effect on the 1st October 2020. So now I have a very quick poll for you, a quick question for you. Are the IP address considered personal information? Yes, no, or maybe? Go to screen sharing. Close it. Close it. Ah. Ah. Stop screen sharing.
So the results are now on screen. And can you see those?
The result, I cannot see the result.
So we have 44% say yes, 28% say no, and 28% say maybe.
Oh, that's very interesting. So actually, the most appropriate answer here is maybe. 28% say maybe. So why is maybe? Because the IP address, including the static IP address and the dynamic IP address. So the static IP address is permanently assigned to a particular computer. And so more likely a static IP address could be used to identify a particular individual. The dynamic IP address is given to any computer for just a specific time. So it can given to this computer for one time and another computer for the next time. So it's less likely that it will be considered as identifying a particular individual. So here, depending on which type IP address, if it is statistic, it's more likely that it will be personal information. But if it is dynamic, then it's less likely. Okay, so I go back to another. My second topic is local data storage requirement. So actually, this is a quite problematic provision set out in the cybersecurity law, Article 26.3 and Article 26.4. Article 26.3 regulates that domestic and foreign enterprise providing the regulated service, which is the service on telecom networks or internet or value-added services in cyberspace in Vietnam, with the activity of collecting, processing personal information or the data on relationship of the service user or the data generated by service user in Vietnam. So those enterprises must store such data in Vietnam for a period described by the government. And more problematic, it is foreign enterprise mentioned in this clause must open branch or rep office in Vietnam. And Article 26.4 saying that the government will provide detailed guidance on this clause. So based on Article 26.4, the government, the Ministry of Public Security have released the first draft of decree for public consultation late 2018 to early 2019. And the latest available version which we can access to is the version on August 2019. Based on that version, we can see that the draft decree narrowed down the broad language of Article 26.3. So only when 3 criteria are fulfilled, then the enterprise will be requested for the local data storage requirement implementation. So what are the 3 criteria? First is that the enterprise must provide the regulated service. And the decree provides the 10 types of service. So it, for example, telecom service, e-commerce service, or social network service. So you have to provide the service in regulated service. The second is that the company have to process the regulated types of data. So what are types of data? First is data on personal information. Second is data generated by service user. And third is data on relationship of service user. And the third criteria is that the company had been warned of the breach of the law and the company did not take any measure to correct it, or the company resisted, obstructed, or ignored the request from relevant authority. So only on 3 criteria fulfilled, then the company will receive the request from the Ministry of Public Security. And after receiving the request, the request can be that you have to store data in Vietnam, or you have to establish a branch or rep office in Vietnam for the offshore company. And then after receiving the request, the enterprise must complete storing the data or establishment of local presence within 6 months from the request. And the duration for storing data is 12 months. Duration for at least 12 months, and the duration for local presence is start from the date of receiving a request until enterprise no longer operate in Vietnam or provide regulated service in Vietnam. So I also have another poll here, another question here. Do companies have to comply with local data storage requirement now? Yes or no, or not yet certain?
Okay, so we have our results in. Do companies have to comply with local data storage requirements now? 51% say yes, 24% say no, and 25% say not yet certain, don't know. So 51% say yes.
Wow, that is very interesting answer. Actually, we just say for the implication. Okay, so we think that more likely that the answer is no, because the decree is not yet promulgated. So in our opinion, I go with 24%. Why? Because generally speaking, the legal system, as the legal system in other countries, the law will have a higher effectiveness than the decree. That means that when there is a conflict between the law and the decree, then the law shall prevail. However, with the provision, we need to wait for further guidance, such as the data localization, because you can see that Article 26.4 of the law stating clearly that the government shall provide detailed guidance on this clause. So with those type of situations, the law enforcement, under the law enforcement perspective in Vietnam, the enforcement authority shall wait for the decree to be promulgated. So you can also say that actually the decree is significantly narrow down the scope of application of the law. So whether you go with the decree or you go with the law, actually in this case the decree narrowed down the scope, but it's not contradict to the law, and the enforcement authority usually commonly shall rely on the decree to enforce. Even some in other cases, you can see that very common in Vietnam that the decree is also not yet detailed enough for implementation, and you have to wait for circular to implement certain provision of the decree and the law. So here, more likely we go with the answer no, because the decree is not yet promulgated. Here, what we have with the local data storage requirement, the implication is that the company will not have to comply with data localization requirement until the cybersecurity decree is promulgated. And also, after 18 months of implementation, we have seen no enforcement regarding to this clause. And also we have advice for the companies to avoid the risk of receiving a warning of breach. So the company should get prepared and should assess the risk of potential violation from the company or operation. So you should identify any area of operation posing the most risk for the violation of cybersecurity law. And the second one is you should get prepared internally to comply with the authority request as much and as soon as possible. For example, you will develop an internal working policy as well as a policy with customer for using your service in order to quickly process and handle requests for coordination from the authority and coordinate with authority as much as you can. If you, for example, if you receive a takedown request that require you to block or delete the violated information within 24 hours, we strongly recommend that you should have the policy or mechanism to deal with this written request within 24 hours, even though you haven't got the chance to communicate with enforcement authority or the customer. So by doing this, you can minimize the risk of receiving the warning. Okay, so I will go with this quickly. For the onshore company which provide the service of social network, online game, or general website, those onshore company also have to pay attention that you have to have at least one server in Vietnam. So now I go quickly to statutory requirement for data breach. So when you have a data and information network, you have to make sure that your information system is secure. The law on network information security provides the requirement in case of data breach and data leakage, and it requires that the provider and user of network service must cooperate with authority to ensure the information security. So when you discover an act of sabotage or any information security incident to the information system, you must notify the owner or administrator of the information system and also the relevant authority within the certain period of time from the date of detection. And also the operator of information system must promptly take remedial and blocking measure. And in case it is a very serious, serious information incident, security incident, then emergency response plans must be implemented. So you can see that there are two types of information security incidents. One is serious and one is non-serious. My colleague Waewpen will talk more about the classification of the information system according to the level of security. But basically, the serious information security relate to the system which have a level 4 or 5. Usually, the level 4 or 5 is the classification of information system. With the number 5 is the highest level, and this level reflects the potential harm that a security breach could cause to other entities, social orders, national security, among other matters. So Waewpen will lead you more about what is the level 4 or 5 and what is serious information security incidents. Here, I want to say very briefly that for all incidents, the information system operator must notify to the information system owner and administrator and relevant authority to immediately carry out the initial incident response activity. And also they have to implement the incident response plan, and all of those requirements regulated in Circular 20/2017. And if the incident is a serious incident, then additional emergency response plans must be implemented, and all of the procedure for implemented additional emergency response plan is regulated in Decision 5/2017. Usually for business operation, depending on each case, we think that it's more commonly and more likely that the information security incident may fall into level 3. It's a non-serious information security incident. So the main responsibility will be notify the incident and promptly taking remedial and blocking measure. So my part is finished here. Now I pass to my colleague Waewpen. She will talk about number 4 and 5. Thank you.
Yeah. Hi, good afternoon, everyone. So again, my name is Waewpen, and I'm Giang colleague. I'm a senior associate at the Tilleke and Gibbins Hanoi office, and specifically in charge of technology, media, and telecom practice. So basically, today I will discuss with you about two main topics. First one, cybersecurity requirement, and second one about validity of the use and legal effect of e-signature and digital signature. So let's go through with the first one, cybersecurity. What is cybersecurity? The law happened to find what is cybersecurity, or which is referred under the law as network information security. Basically, it means that it's the measure to protect your database and information system from any illegal access, use, disclosure, disruption, amendment, or sabotage. Basically, it's just like the measures required for you to implement in order to secure your network and information. And then basically what are required to be secured. Basically, it will include hardware, software, database, anything related to online data processing. Like showing in this picture, first, this is your data, right? And then the cybersecurity requirement will help you to protect the cybersecurity from outside. For example, spyware, cyber attack, hacking, human error, virus, data virus, and so on. Then let's discuss about the law. What kind of law that regulated cybersecurity? Basically, it will have general law and also sector-specific law. Mainly, cybersecurity will be discussed under the law on network information security and also its subordinated registration. For example, Decree 85 related to security of network system, and Circular 03, which is further guidance for Decree 85. And then for certain specific sector, in addition to compliance with the general cybersecurity requirement, you also need to have specific additional cybersecurity. For example, in healthcare sector, they also have specific circular for the measures required, and especially for financial sector, this will be very detailed and very stringent measure that the financial institution need to comply. Then, who need to comply with the cybersecurity requirement? Basically, it will be any owner of data system that is physically located in Vietnam. For example, if you are a Vietnamese company and you have data center server located in Vietnam, and in this case, it will be obvious that your database will be subject to the cybersecurity requirement. And secondly, even though you are not a Vietnamese company, like for example, if you are a Singapore company, but you happen to have your server located in Vietnam, or you lease some data center space in data center in Vietnam, this local database will also need to comply with the Vietnamese cybersecurity requirement. And then secondly, if you happen to provide services in specific sector, for example, like healthcare sector or financial sector, in this case, if you are a licensed operator in Vietnam, for example, if you are a licensed Vietnamese bank or Vietnamese payment processor, then regardless of where your database will be located in Vietnam or outside of Vietnam, those databases under your control need to comply with this specific law. Then, what are actually the measures required to protect your database? Basically, the measure required to protect your database or cybersecurity measures is vary and depend on the type or level of your information system. So basically, the law classified information system into 5 levels from 1 to 5, and then 1 is the least important and 5 is the maximum important. Let's go into detail. Like level 1, it will be just data system of internal use of a company, which does not concern customer data. And then second level, it will be a little bit higher. It will be data system of a company that provide online services. But these online services are not regarded as conditional business under Vietnamese law. For example, online data processing company, online data storage, cloud processing. So these are level 2. And then level 3, it will be more higher. It will be the database of the online service provider who are regarded as conditional business line under Vietnamese law. For example, e-commerce activities, insurance, financial institutions, telecom, social network, online games. Or if it's even not conditional business line, but if you are processing user data of more than 1,000 or 10,000 users, so it will be considered as level 3 as well. And level 4 and 5, it will be something related to government agency at a national level. Level 4 will be National Information System of government-related agencies, and level 5, it will be centralized storage of vital information and data of the country. So basically, I think most of the companies, their database who provide services to customer may fall under level 2 and level 3. So I will guide you to and provide some information of what are the salient and key cybersecurity requirements for these 2 levels. For example, level 2, the one who provide online services, but those services are not regarded as conditional business line. So basically, you will see there are 2 sides of the chart, right? So the left one will be the technical requirement. It will be the requirement that your IT team need to implement to make the requirement under the law. And then on the right-hand side, it will be the managerial requirement, which is the policy or plan that the company need to implement for employee and other staff. Let's go into detail for the technical requirement. So it will break down into like 4 sub requirements. First one, national network infrastructure security. So basically, you are required to separate the type of network, and then server security, it will be, for example, you need to have anti-malware software used for your system, and it must be automatically updated, and also need to have some password authentication for the admin who get access to the server. All of this just to ensure security. And then for data security, you may need to back up the important data on the server. And then for the managerial side, you need to have information security policy implemented. And then I would like to draw your attention into the operational management one. In this case, it requires that the company who provide who operate system in level 2, they need to have the procedure to handle about the cybersecurity incident. So in this case, it will be the plan that the company need to have it in advance on how they need to deal when they have like data leakage or data incidents, and who they need to report to and within what specific timeline. So these are the requirements that the law requires the company to be aware of. And then lastly, about the inspection and assessment. So basically, the law requires you to have the inspection and assessment every 2 years. For level 3, because the system is more important, it will be more details. But I will just draw you into some noteworthy one. For example, the managerial requirement, you need to have a training for your IT manager and staff to be like freshen up their knowledge about cybersecurity protection, what is the new technology that they need to comply with. And then you need to educate your employees about how to secure information, especially information of the customer, and also have their commitment that they need to comply strictly with the policy. And also in terms of inspection and assessment, you need to inspect and assess it every year. And then it needs to be done by professional organization who is licensed to provide the system inspection and assessment services. So you cannot do it by yourself. And then if you think that your company already comply with the requirement under the law, then do you need to comply with any international standard on how to protect your cybersecurity system? For example, does the law require you to also comply with ISO 27001? And then in this case, the answer is no. Actually, the law does not require you to obtain any specific standard. But actually, the law is encourage you to do so. Vietnam also have its own national standard on cybersecurity, which is the standard number TCVN ISO 20001, and this is promulgated by the Ministry of Science and Technology. But this is a recommendation for voluntary basis only. The law does not actually require any company to specifically comply with this standard. And then, if your company is a global company and already comply with this ISO, is it sufficient? Do you still need to comply with the Vietnamese standard? The answer is no. It also depends on if your data information is level 2 or below. So in that case, it may be sufficient. But if the data is level 3 and above, or it is a database of a specific sector, for example, like healthcare or financial sector, so in that case, it might not be sufficient. Because for this specific sector, the law specifically requires them to comply with a specific standard. For example, for healthcare sector, it will be a list of standards that the healthcare service provider who provide online IT application related to healthcare services need to comply, and it will be, for example, like health level 7 standard, health level 7 CDA standard, and so on. And then for the financial sector, basically, the law does not specifically require the financial institution to comply with any specific standard, but it needs to comply with the requirement under the financial law. And for example, Decree 165 related to e-transaction in financial operation, Circular 35 related to internet banking, Circular 37 related to card payment. And this is the end of the cybersecurity. And then for the next section, I would like to discuss about the validity of e-signatures and digital signature under Vietnamese law. What is e-signature? Basically, e-signature is defined under the law as a form of words, letter, numbers, symbol, sound, or other form is electronic form that is associated or attached with the data message, and also be able to identify the person who used such e-signature, and also his approval on the content in the data message where the e-signature is affixed. The law that governing the use of e-signature is mainly the law on e-transaction, and also Decree 130 about digital signature and digital signature authentication. Then what would be a question that are all types of e-signature valid under Vietnamese law? The answer is no. E-signature will be valid only in the case that it satisfies the following two conditions set out by law. The first one, the method of creating e-signature must be sufficient enough to identify the signatory and also his or her approval on content of the data message. And then secondly, the method that creates e-signature must be sufficiently reliable and appropriate for the purpose for which the data message was created and sent. Basically, this is very general and vague. So how can a person identify whether the method that they create, the e-signature, will be sufficient or not? And this will create a room for any person to argue that the e-signature used by one party is valid or not valid under Vietnamese law. And then the law suggests that the e-signature may be considered secure enough if it meets the conditions set out by law. For example, if the data creating the e-signature is only under control of the signatory at the time of signing, or the change to the contents of the data message after the time of signing is attachable. Like alternatively, yes. Alternatively, if you use a digital signature issued by the licensed service provider who provide e-signature certification services, this could be considered as secure and sufficient under Vietnamese law also. Like there will be an important note that if the data document or contract is mandatorily required to be affixed with a company seal, in this case the law specifically requires that the signatory must use digital signature only. The general e-signature is not sufficient. Then well, we will discuss on what is considered as e-signature, digital signature under Vietnamese law. Basically, digital signature is a type of e-signature, but the method to create digital signature is secure. It will be created by a person who have a private key, and then the person who have a public key will be able to use the public key to verify who is the signatory of this digital signature, and also whether the information, the data used this digital signature have been changes after the time that they affix with the digital signature or not. Basically, it will be more secure than ordinary e-signature, and then but validity of the digital signature will be valid only in the case that it is issued by the organization licensed by the Ministry of Information and Communication to provide e-signature certification services. For example, if you use digital signature but it's issued by the non-licensed operator, it will not be valid under Vietnamese law. And again, it's very important to know that if your document required to affix with a company seal to have a legal effect, in that case, it needs to affix with digital signature only. It cannot use only e-signature. Like you can see from this picture, if the document is only required to sign by a person, so electronic signature or e-signature is sufficient. But on the other hand, if the document or a contract is required by law to sign by signature of the signatory and also affix with a company seal, in this case, they must use digital signature. And next one, who are the licensed service provider who can provide digital signature services? Basically, currently it have only 12 companies who are licensed to provide digital signature services. And the notable one is Viettel, VNPT, FPT, CMC. So if you would like to use digital signature in your transactions and documents, you must obtain the digital signature from these service provider only. And then how about foreign digital signature? For example, if you would like DocuSign or HelloSign, will the digital signature issued by this company valid under Vietnamese law? And then the answer is depend on who use it. Like it could be valid, but depending on the user of the foreign digital signature. So in this case, the law provides that if the user of the digital signature is foreign entity or individual, it will be acceptable, or otherwise it is a Vietnamese company or individual which have the need to use digital signature for international transaction, and then the Vietnamese digital signature is not acceptable in such transaction. So in this case, the Vietnamese company and individual will be eligible to use the foreign digital signature also. And then the law also further provide into details that in case the user is the Vietnamese company, and also in the case that the user is foreign entity or individual, but they happen to have business presence in Vietnam, for example, foreign invested company or a branch office or representative office of the foreign company, or even foreign individual who is living in Vietnam. So in this case, if they would like to use foreign digital signature, they must also obtain a separate license for use foreign digital signature from the Ministry of Information and Communication to ensure that validity of the foreign digital signature in this case will be acceptable under the law. And this is the end of my presentations. And then if you have any questions, so please raise it here.
Well, thank you very, very much. That was a very comprehensive presentation indeed. And we have got a couple of questions that have come through from the audience. I shall read them out. Do you have any updates on the status of the digital signature, e-signature being accepted by Vietnamese government agencies, e.g. the police department and Vietnamese court and arbitration?
Yeah, this is very good good question indeed. There is somehow digital signature somehow, even though the law recognize validity of the e-signature and digital signature, right? But in practice, we also find that there will be some difficulty for the party who would like to use digital signature or e-signature in the court. Because in practice, before you can show any document to the court, right, you have to have the document certified by the notary public in Vietnam first, and then in this case it will become problematic because nowadays the notary public in Vietnam, they oftenly refuse to certify any digital document, even though it have some legal basis saying that the document would be valid under Vietnamese law, but in practice, because Vietnam is very formalistic jurisdiction, so we found in certain cases the company will be like fail to use e-signature or e-signature or digital signature to enforce this in Vietnam.
Right. Actually, you partially answered, I think, the next question, which was from the audience, which was, can you share the acceptance of e-signatures and digital signatures in reality? So I think you partially answered that there.
Acceptance?
And how actually they are accepted, how much they are accepted in reality.
Yeah, basically it would be more acceptable in like in the private sector, but mostly if you would like to use e-signature or digital signature in the document that you need to submit to the government authority. So in that case, like we found that in reality the officers may doubt and have some questions about the use of e-signature and digital e-signature, and they prefer the companies still use the wet signature when they need to submit document to the authority.
Right. Another question here, any requirement or watch out for an opt-in on websites to be considered as explicit content? Consent, sorry.
Consent.
For the explicit consent, actually the decree 52 on e-commerce provide very clearly on the what is the express consent. So there are the rules. First is that you have to display the privacy policy very clearly to consumer. When consumer go to the website, they have to see the privacy policy very clear. And the second is that you have to develop a mechanism for the consumer to expressly say that they consent. For example, you have a button on your the website saying I accept. So they have to click on that button to go into the website. And then if you transfer the personal information of consumer to the third party for advertising purpose, you have to develop a separate mechanism for additional consent. So you also have something in the like a pop-up or something in your website so that the consumer have to click on. So this kind of the tool is the express consent. You can obtain the express consent by sending email to client to the user and saying that if they want to express consent, they subscribe or they send the email to them to you. So it's also the express consent.
Mm-hmm. Just to add more information about this one, the requirement that Giang just discussed is only imposed on the e-commerce website only, but not other types of websites. So basically, if your website just like provide other services or just social network, online game or something, so you are feel free to create your own mechanism to obtain the consent. And also, like even though you are e-commerce website, but if you are offshore website, for example, if you are website.us.com.us, you are not required to comply with Vietnamese law. Yeah, only the website that is established in Vietnam.
But usually we advise the client that this is not clear cut. So it's better that if they can develop something, some tool or some way of obtaining the express consent from the consumer is better for their protection.
Mm-hmm.
Excellent. We have another couple of questions come in. We'll see how much time we have. The next one's back to e-signatures again. Regarding the use of digital signatures, is there any regulation on the types of transaction to be accepted? More particularly, is it acceptable if we use it on decisions, resolutions of foreign investors?
I understand that it will be like internal decisions of the boards of directors of the companies, right? And in this case, it will be internal use. So basically, as long as like it is written in the like charter of the company that the board are able to use e-signature or digital signature when they like approve their board resolution. So in this case, it will be acceptable. But if they will use this copy of board resolution with third party, for example, if the board resolution is related to increase of the company capital and then it need to submit as an evidence to the government authority. So in that case, I'm afraid that the officer may still require the board to use a traditional way and like have a wet signature in that particular cases.
Okay, so I have a few questions, but I'll ask these as the last two questions because of time. For collection IP, is it acceptable to pre-tick the checkbox when requesting the consent form or consent from the consumer?
Yeah, as we said that the law generally do not regulate in detail and clearly how you will obtain consent from the users or consumers. So you can develop any type a mechanism to obtain consent. So if the tick box is okay, if they can tick the box and then they to show that the consumer and the user read everything and they consent to the content, then it's okay.
Yeah,
Okay.
but I think in this case, like out of prudence, like it can be pre-ticked, right? But at the end, at the bottom, the user need to click I accept again. But like at like above, right, it will be a lot of like tick box and then it can be pre-ticked. But at the end, they still need to express their consent that I agree for the above information. So in that case, it should be sufficient enough. But if it's pre-ticked and then the user are not aware at all that it's pre-ticked, so in that case it would be more risky.
Okay, so I'll make this the last question that I'll ask within the forum itself. Regarding the way of expressing consent of customers, do you think that keeping information of your customer in your database without their prior consent is violated already? So do you think it's a violation? I think that this means to keep the customer information in the database.
Keeping because the law, you can see that there are quite a few laws applicable to the privacy. So you can first you have to find out which is the law relevant. But usually the collection, processing, storing of the personal information must have consent from the personal information owner. So even you store, you collect and the store, that action constitutes the action of collecting and storing and processing of the and storing of the personal information, and you have to seek consent.
Yeah, you cannot store it without collection. So somehow it needs to be inputted into your system first, right? And then that part will be considered as collections already. So you need to have consent since the time that you receive the information.
And the law on information network security even requires a very stricter consent than the other law. They said that the information owner must know the purpose of the collection and processing of the information before they give the consent. So I mean, you cannot store the personal information without the people consent. But actually, this is the law, the regulation of the law. But in practice, it may be different. I mean, in practice, because the privacy law in Vietnam, implementation enforcement of it is still very loose. It's not as strict as the regulation in the law and the regulation. So in practice, maybe many people store the personal information without consent, and there is no issue on that because there is no enforcement.
Yeah, but does not mean that they comply with the law. The violation is still there, but the enforcement is another issue.
Yes.
Understood. Well, wonderful. Giang and Waewpen, thank you very much for that comprehensive session. We covered a lot of ground, and I know there are more questions, but what I'll say to everybody is I know that Giang and Waewpen would love to hear from you. I think Raoul has actually shared, my colleague has shared their email addresses on the little the chat box on the side of your screen there, and we'll also share their email addresses after this afternoon sessions, both sessions are over, by email to you all. So please do get in touch with them both. They'd love to hear from you, and also I'm sure they'd be happy to share some slides and further information with you should you require. But for now, thank you very much, and thank you for Tilleke and Gibbins for putting together that excellent session. Thank you.
Thank you.